Your Honor, this case proceeded to trial. The Commonwealth proved beyond a reasonable doubt that on February 4th, 2010, officers of the Ayer Police Department were dispatched to advanced vacuum systems on Fitchburg Road in Ayer to report an ex-employee making threats. The dispatcher stated that the threats were made to kill the reporting parties and other on scene, that the subject appeared to be intoxicated and was possibly outside the building. Upon arrival, Ayer Police were unable to locate the defendant's vehicle. They then went in and spoke with employees at Advanced Vacuum Systems. One employee stated that the defendant, Stanley Bielinksi, had been laid off 2 weeks ago and unexpectedly showed up at Advanced Vacuum Systems and appeared to be intoxicated. He stated that when the suspect arrived, he went directly into the president's office and began arguing with the company president. This argument then escalated. The employee has stated he observed the defendant going through his pockets multiple times as he was being escorted from the building, and the employee felt that he may have been looking for a gun. The officers asked the employee why he believed that. He stated that most everyone at the employment office knew that Mr. Bielinksi was a Vietnam War veteran and was rumored to have several guns. He added that he attempted and observed the defendant hit the company president as being escorted from the building. The Ayer Police Department then spoke with the company president, who stated that he was on the phone in his office when the defendant arrived, appeared very drunk and very angry. The defendant batted one of the chairs in front of the president's desk, left the office for the moment, and then came back. At this time, the company president attempted to call 911 without the defendant knowing. The president stated that the defendant was belligerent and told him that he had fucked him. The defendant then grabbed the company president and said, "If you ever call the cops, I will kill you." At this point, other two employees came in and walked the defendant to the rear of the door. The defendant at this time attempted to punch the company president. However, the president was able to back away to avoid getting hit. The company president also stated he saw the suspect go through his pockets, in which he believed he may be looking for a gun. Ayer Police Department then spoke with two other employees at this time, who stated that the defendant was very upset and told one of the company employees to not fucking talk or he will shoot him. The suspect blamed him from getting laid off and appeared to be drunk. He stated that he did see the defendant lunge towards the company president as he was trying to get out of the building. Another company employee also stated that he heard the defendant threaten to shoot another company employee. At this time, it was found out that the Ayer Police Department found out that Mr. Bielinksi lived in Shirley. The Ayer Police Department then responded to Shirley at his address and saw that the Shirley police had the defendant in custody at that point. The defendant told the officer that he was at Advanced Vacuum Systems and that he had 4 beers. And Judge, it should be noted that the Shirley police, and that is the subject of another case. However, it just should be noticed that there were firearms found in Mr. Bielinski's home. Those are essentially the facts of the case.
All right, sir, did you hear those facts?
Yes, Your Honor.
And you've had a chance to go over those facts with your attorney?
Not all them facts. No, I did not. I was laid off for a year, not 3 weeks. I was laid off February of 2009, not 2010, like she said.
All right, but those facts, sir, don't go to the elements of the offenses.
And
you understand that by changing your plea today, you do admit there are facts sufficient to warrant the finding of guilt as to each of these offenses. You don't understand that, sir?
No, I did, because there's things in there I didn't do.
Right.
I mean, I did. I touched the president. I did not grab him. I told him, will you listen to me? He wouldn't listen to me. I was laid off for a year.
Well, sir, you were the one that's offered the tender of plea, and you indicate that by doing so that there are facts sufficient to warrant a finding of guilt as to assault and battery on Mr. Levesque, assault on Mr. Levesque, disorderly conduct, and 2 counts of threatening to commit a crime, and the facts as to the intimidation of a witness.
Judge, the facts, when he allegedly grabbed the president and stated, if you ever call the cops, I'll kill you.
I did not say that.
All right, sir, if you have a dispute as to the facts, we can have a trial of the matter. Do you want a second call, counsel, or is it on for trial?
It's not on the trial.
No. No, I'd like to get it over with, if I could today, I mean.
Well, I can't accept your plea, sir, if you don't admit to the wrongdoing that is set forth in the factual recitation.
I did wrongdoing, yes, I did, I admit to that.
So,
I'm very sorry for it, I was angry.
No, I understand you're admitting that some of the, or you're stating that some of the statements in the report about dates and things of that nature are not accurate. But you don't dispute the allegations about your contact with Mr. Levesque, your statements to him at the scene. Is that true, sir?
Yes, yes.
Well, I don't want you to guess, sir.
Just speak clear. Do you need more time to speak to me?
Yeah,
All right, we'll give it a second call.
Thank you.
And you've gone over those facts with your attorney.
yes, Your Honor.
You understand that by changing your plea today, you do admit that those facts are true as they relate to the offenses.
Yes, Your Honor.
Has anybody forced you to change your plea today?
Nobody.
Has anyone made threats or promises in an effort to induce you to change your plea?
No, no,
You
sir.
are doing so today, freely and voluntarily?
On my own, yes, sir.
You've had enough time to think about it, sir?
Yes, sir.
You've had enough time to go over it with your attorney?
Yes, sir.
You're satisfied your attorney has been acting in your best interest?
Yes, sir.
You understand that if you were not a citizen of the United States, the effect of your admission or the disposition of the case could be deportation, exclusion from the United States, or denial of any rights to naturalization you may have under the laws of the United States.
I'm a citizen.
But I have to give you that warning. So,
Okay, sir.
we have probation records.
No, Judge. I called and they were allegedly on their way in.
All right, well, I think I'm...
Would you like my... Judge, the defendant hasn't sent her number.
Does he have other open cases?
No, Your Honor.
Judge, she does have one more open.
Oh, I apologize.
Yeah. All right, Commonwealth?
Judge, the Commonwealth's recommendation is guilty, 2 years, house of correction, 6 months to serve, bail suspended for 3 years, stay away from the president, the company, and its employees, no abuse, substance abuse eval and follow-up, random screens, no drugs or alcohol, mental health eval and follow-up, and no firearms. The Commonwealth understands that the defendant has essentially no record. However, unfortunately, Your Honor, this is a very scary incident for this company and for the president himself. The Commonwealth has been in constant contact with the company president about this incident. Just unfortunately, throughout the Commonwealth and throughout the United States, you hear about these incidents that occur, ex-employees getting angry, going back into businesses, and unfortunately, sometimes it ends up in casualty. We are lucky in this case that it did not happen. However, the defendant did come in intoxicated. He did threaten to kill employees. He did hit the company president. He did threaten the company president. Judge, we are lucky in this case that no casualties had occurred in this manner. And based on the scary nature of this case and the incident and the unfortunate incident that could have occurred in this case, and much of which happens throughout the Commonwealth and in the United States, the Commonwealth is taking this case very seriously, and we believe that due to the circumstances of the case that some committed time, a split sentence is appropriate.
Yes, Your Honor, since the case was arraigned, I've had many opportunities to meet with Mr. Bielinksi. And I just want to respond to the facts which have been placed before the court first. Mr. Bielinksi worked for AVS for 30 years. He was laid off along with a number of other people. He wanted his job back and he drove by. He saw lots of new cars in the parking lot. He works in the same area that he lives in. And he went in to find out about getting his job back. And he went to talk to the president about getting his job back. The president did not want to speak to him. Mr. Bielinksi was upset. He had many friends at this place of employment where he had been working full-time for 30 years. When the president wouldn't speak to him, Mr. Bielinksi wanted to get the president's attention. He did touch him. He did admit this to the court. He did touch him. He was upset. He did have a couple of beers. And then he left. And then he went home, and the police came to him at his home. They did not arrest him. They knew about the allegations, about the drinking. They didn't field test him, even though he wanted to be taken for testing. They didn't do that. They didn't hold him, and they didn't arrest him. They heard about the allegations about the weapons. They asked him if he had any guns. He said yes. The police entered his house with his permission. He voluntarily gave up all the guns. The guns are gone. Now as to Mr. Bielinksi, who has made a recommendation to be fair to the Commonwealth, to be fair to the safety of the public, to be fair to Mr. Bielinksi, to be fair to the safety of the Commonwealth. He's admitting what he's done is wrong. He's being willing to go into the structure of probation for 3 years. He's being willing to go for mental health evaluation and follow the recommendations, which is prudent because he suffers from depression and takes medication for the depression. And the medication was off balance when this happened. He continues to take the medication today and correct it. Mr. Bielinksi is 63. He served in the United States Marines from 1966 to 1969. He's a combat veteran of Vietnam War. When he came back, he went to work in his field of training in the military and worked for the same company for 30 years. At the same time, he exercised his right to own firearms. He belonged to the Ayer Gun and Sportsman's Club for 22 years. During that time, he ran a fishing derby for disabled veterans for 6 years. And during that time, Your Honor, he played Santa Claus for children for 5 years at the Ayer Gun and Sportsman's Club. He is still a member, Your Honor. To be fair to Mr. Bielinksi, Your Honor, this person was last in the courtroom in 1974, over 35 years ago, in this court. He has only been in court twice in his life. Both times, the cases did not go against him. One case was dismissed, and the other case was also dismissed. Your Honor, we think this is a fair resolution to the safety of the general public. In addition, Your Honor, Mr. Bielinksi, to be fair to him and his family, he lives with his wife, who he's been with for 35 years. Mrs. Bielinksi is 53 years old. She is disabled, with numerous spine operations, with epilepsy, and with diabetes. She is essentially bedridden. She only leaves the house to go to physician's appointments where Mr. Bielinski takes her. And in fact, she's completely bedridden now because within the last 30 days, she fell at home and broke her shoulder. Essentially, today, Mr. Bielinski is her 24/7 caretaker. Again, this recommendation is designed to be fair to the Commonwealth, to the prosecution, and to Mr. Bielinski to ensure his behavior conformed with society and to give him the structure of probation and the structure of the mental health evaluation and the recommendations to help him be in compliance. Thank you. Can I speak very briefly? As far as the guns, Your Honor, there are no more guns in Mr. Bielinski's possession in Mr. Bielinski's home.
No, is that the open case? Is that?
Yes, there's correct, there are no more guns in his home, but there is an open matter in regards to that.
And for Mr. Bielinski to have any guns, he would have to apply to the chief of police at his locality, and he's aware of that. He did have an FID card at one time. So the guns are not an issue for Mr. Bielinski. And the substance abuse is not an issue for Mr. Bielinski. The issue is him taking care of himself, which he's not doing. Thank you.
All right, thank you. Does he admit that alcohol was a contributing factor because he's in this situation? Is he willing to stay alcohol-free?
Give me just a moment. Can you hear me?
Yeah.
Are you willing to stay alcohol-free? So probation? Yes.
Probation, I wasn't charged with it.
Your Honor, Mr. Bielinski states that alcohol was not a contributing factor, and he was not charged with any alcohol issues, and indeed he wasn't.
Well, he admitted to the...
He admitted to police he had a couple of beers.
Okay, the sentence would be on 1, 2, 3, 5, and 6. It would be a continue without a warning for 3 years until November 8th, 2013. And the conditions are that you stay away and have no contact with the named victim, and stay away from the company complex, that you submit to mental health treatment and stay on all medications, that you remain alcohol-free, and submit to random breath tests, and have no possession of any firearms, undergo a mental health evaluation, and follow any additional mental health treatment that's recommended, and also a substance abuse evaluation and all follow-up as recommended. And on count 4, it's guilty and placed on file. And there's a $50 victim witness fee on count number 1, and a $65 per month probation supervision fee.
May we have a brief second call?
He should be aware with the medications he's taking. He shouldn't be drinking alcohol. Problematic.
Yes, thank you.
Second call.
Thank you.
In the court's disposition, Sarah, so you'll need to see probation and sign.
The only thing, Judge, that he wants to do instead of paying the PSF, he'd like to do community service.
You'll have the community service option.
Judge,
Thank you.
I'm sorry, in regards to the other case, the Commonwealth has filed a Rule 17 motion in that matter. The guns were sent to the Village Vault storage facility, where they were then sold to a third party. The Commonwealth is requesting the business records from the Village Vault of that transaction of Mr. Bielinski's gun to that third party.
Post-arrest, the weapons were transferred.
Yes, Your Honor.
Judge, essentially, they were taken by the Shirley Police Department. They were mistakenly sent to the Village Vault, where the Village Vault sold them to a third party. So I'm in the process of essentially hunting them down. So my first step would be to ask for the business records. I've talked to the Village Vault. They are would have no problem complying with the order and sending the records to the clerk's office. I was just would ask to file a Rule 17 motion to allow that. And we can have the same motion date stand on 12/10.
The guns are gone, you know, they're gone, and the Commonwealth does not have possession of the evidence. At the next date, I'll be filing an oral motion to dismiss the case for lack of evidence, and December 10th is the next date. The Commonwealth has known this since early on, that the guns are not in the possession of the Commonwealth, and haven't been for quite a long time.
Motion's allowed.
Thank you.
Thank you.
It was the same motion, it was 12/10.